The court acknowledges the officer's testimony and then addresses the defendant's unusual request. The judge makes it clear that the court cannot be assigned the role of a trustee. Its function is to remain neutral, serving as an impartial decision-maker, not as legal counsel or a personal representative for either side. The commentary then explains where this argument typically comes from. Some individuals attempt to label court officials as trustees in order to claim a conflict of interest, which would, in theory, require the judge to step aside. The idea is that this process could repeat with each new assignment, potentially delaying or disrupting the case. However, the reality is far different. Courts do not operate under that framework, and such claims have no legal foundation. As a result, these arguments are consistently rejected, and the case proceeds under standard judicial procedure.
So, to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase T-E-P-E-H-E-N, capital S, lowercase M-I-T-H.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL.
The narration recaps the officer's testimony, noting that the sequence of events appears fairly direct. According to the record, the defendant was stopped and did not inform the officer that he held a concealed pistol license while carrying a concealed firearm, something required under Michigan law, specifically MCL 28.425B. From a legal standpoint, this type of allegation can be addressed with a structured defense strategy, and an experienced attorney would typically focus on the specific facts and procedural details of the stop. The narrator then shifts focus, inviting viewers to see how the defendant chooses to respond on his own, without legal representation.
So, it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
The narration explains that the initial reason for the stop was a suspected violation. Specifically, illegal tint on the front windshield, as described by the officer. That observation provided the basis for initiating the traffic stop. It then addresses the defendant's claim that the stop was motivated by race. The narrator points out an apparent inconsistency. If the windshield tint was significant enough to limit visibility, it raises the question of how the officer could have identified the driver's appearance before making the stop.
Option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL. Until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
In this portion, the narrator breaks down the defendant's argument, pointing out both its weaknesses and its strengths. Starting with the weaker point, the defendant relied on the idea that the stop was invalid because the officer may not have initially mentioned the window tint. The issue with that claim is twofold. There's no supporting evidence like audio or video, and more importantly, it wouldn't change the outcome. By acknowledging the presence of tint on the front windshield, where any level of tint is prohibited under Michigan law, the officer had sufficient probable cause to initiate the stop. On the other hand, the narrator highlights a more effective argument. The defendant noted that no actual test was conducted to confirm the presence or level of tint. In theory, that could create doubt regarding a minor equipment violation, since a claim alone isn't the same as verified evidence. However, even if that point raises questions about the tint citation, it does not resolve the other alleged violations connected to the stop. With those considerations in mind, the court moves forward, prepared to issue a ruling, beginning with the equipment-related charge tied to the B ticket.
Your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield, while I believe it was racial profiling. Considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone, because like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So
That brings us to the end of this segment. It's one of those cases where you can see some potential. The defendant comes across as young and capable, but clearly headed in the wrong direction when it comes to understanding the law. With the right guidance and a more grounded approach, that same energy could be put to much better use. Now, we move on to the next case. This one involves a defendant from Wisconsin whose bond was revoked after failing to treat a court appearance as mandatory. As a result, future proceedings will take place with far stricter conditions in place, highlighting just how seriously the court views compliance with its orders.
After he said I pulled myself over, he flashed his lights, and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person, so I didn't feel the need to, because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation, and I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint, and you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So, yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't.
The judge pushes back on that claim, pointing out that the situation wasn't involuntary. The defendant had acknowledged that a prior judge asked direct questions, and choosing not to respond can be treated as contempt of court, especially when it occurs in the courtroom itself. That kind of conduct can also justify revoking bond, since it reflects a failure to comply with court expectations. Given the circumstances, the court strongly suggests that the defendant allow a public defender to take the lead, noting that continuing to speak without a clear legal strategy may only make the situation more difficult.
So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction. For a first offense, there's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before. Sorry, I wasn't actually engaged in a traffic stop. That was the problem.
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket this morning.
The commentary challenges the defendant's claim of acting in good faith, pointing out that refusing to answer a judge's questions is still a deliberate decision. While a person has the right to remain silent in certain situations, exercising that choice in a courtroom setting can carry serious consequences, including contempt. At this stage, both sides have presented their positions regarding bond. With those arguments on the record, the court moves forward to deliver its ruling.
Call 24 CF 1527, State of Wisconsin versus Gregory Robinson for a bail hearing. Appearances.
ABA Cecilia Mark.
To understand what are the public defender's office appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
I have a copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail could apply to that amount. The defendant have already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that amount back down to $3,000, applying the previous amount. So in essence, allowing the defendant's release after he remained in custody. That release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I'm asking all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on one second.
Okay, that's me. Holding that for you.
I have no objection, and that's how he wants to proceed. If you're right, just so you know, if you do indicate you do not want a public offender, and that's what I happen to be, so I'm happy to withdraw.
The judge delivers a firm conclusion, pointing out the clear contradiction in the defendant's position. On one hand, he claims he wants to be released and move forward with his life. On the other, his actions, missing court dates, refusing to respond to a judge's questions, and resisting participation even while in custody, suggest a pattern of non-compliance. From the court's perspective, those choices reinforce the decision to keep him in custody, as they raise concerns about whether he would follow court orders if released. With that, the segment comes to a close. Any future developments will be covered as they arise, and the case remains one to watch as it progresses through the system.